Welcome everyone to our webinar on protecting your business, best practice for preventing employee competitors. My name is Jess Prebble and I'm a Senior Associate in LegalVision's Disputes team. Now, before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email, so please submit your questions in the Q&A box and I will do my best to answer them at the end. And please complete the feedback survey at the end of the webinar. For the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. Provide your contact details in the survey at the end. Now, we do have a poll question. If you could take a moment to answer, which of the following do you most want to understand better? Employment agreement essentials, protecting confidential information and IP, steps to take when someone resigns, enforcing restraints of trade, or not sure, just here to learn. And I'll answer that after you've submitted those in about 2 minutes. So today we will be discussing employee obligations and employment contracts, protecting confidential information and intellectual property, workplace and IT surveillance, information barriers and limiting employee access, what to do when an employee resigns, a step-by-step guide to enforcing a restraint of trade, the litigation alternatives and considerations, some of the remedies, and lastly, some of the key takeaways. Employee obligations can be derived from the express terms of the employment agreement, such as an express confidentiality clause or a restraint of trade clause. Now, in New Zealand, employees have several key obligations under the Employment Relations Act to help maintain a fair, safe, and productive work environment. The main obligations of an employee is to act in good faith towards their employer. This includes being honest and having good communication, not misleading or deceiving the employer, cooperating and being responsive in employment matters, and following all lawful and reasonable instructions. Employees do also have a duty of loyalty, which includes not working in a way that competes with their employer, not disclosing confidential information, and acting in the best interests of the employer while they're employed. The best way for an employer to enforce these obligations is through a carefully drafted term in the contract of employment. All right, I've got the poll. We're pretty close between protecting confidential info and IP. Employment agreement essentials, to be honest, are actually almost everyone wants to learn 25% of everything except for not sure, just here to learn. So there you go. I'll keep going. Now, it is important to include carefully drafted restraint clauses in your employment contracts. A restraint of trade clause is useful because it helps a business's legitimate commercial interests after an employee leaves their job. These clauses are particularly important in industries where companies have sensitive information, client relationships, or trade secrets. There are two types of restraint clauses: non-solicitation and non-compete. Now, restraint clauses prohibit employees from soliciting customers, soliciting employees, or working for a competitor. Now, why do we need these restraint clauses? You will see on this slide where we set out why a restraint clause is useful. As a business, you invest time and money developing proprietary information that gives you a commercial advantage. You build a client base, you establish a network of key suppliers and stakeholders, and you recruit, train, and retain high-performing employees. Now, your business could suffer greatly if one of the employees decides to leave and establish an identical business to yours, actively pursue your most valuable customers, or recruit your most high-performing employees. And without a restraint clause, you can't stop that employee from engaging in that competitive conduct. Now, what should you do? The devil is in the details. Restraint clauses must be drafted carefully, having regard to the case law. When challenged in court, a restraint clause is generally unenforceable unless the employer can prove that the clause is reasonable and does no more than to protect the legitimate interest of the employer. Now, it might be helpful to give you a few examples of unenforceable restraint clauses. Restraining an employee from approaching all your customers. It's unreasonable to expect an employee to know all of your customers, including past and present. But if the clause simply prevents an employee from approaching only the customers that the employee had direct dealings with in the last 6 to 12 months, the clause is likely to be enforceable. Another example, restraining an employee from working for a business in the same industry for 3 years from the date of termination. This is considered way too long. It's also unreasonable to expect an employee to leave the industry and find a job elsewhere. An enforceable clause would prevent an employee from working for a direct competitor for a period of about 6 to 12 months. What is considered a reasonable duration depends on the seniority of the employee, how intimate they were with key customers, and their salary. In situations where with non-technical employees, where legitimate proprietary interest is established, non-competes for more than 3 months are likely unenforceable. 6 to 12 months is considered reasonable for most mid to senior level employees, but a longer period may be considered to be acceptable for senior execs. Non-solicitation clauses may be enforced for longer periods and for wider geographic areas, but 6 months is a probable upper limit for highly valued specialised connections. So as you can see, it's important to tailor the clause to each employee. Courts will not fix or amend unreasonable restraint clauses. If any part of the clause is considered unreasonable, courts will strike out all of the unreasonable parts, in which case you're likely left with no protection. Historically, there was discussion in New Zealand in about 2023 about introducing a restraint of trade amendment bill, whereby there was a limit on a restraint of trades to 6 months. However, this bill was never passed, but it gives you a good indication. Now, separate to restraint clauses, you should also include clauses protecting your confidential information and IP. Employees have the potential to become competitors, might steal customer lists, trade secrets, documents and information that will make it easier to service those customers. In the case of software companies, the employees may steal source codes or ideas. In the case of consumer goods companies, employees may steal product ideas, information on product launches, and the marketing strategy. If your business relies heavily on trade secrets to drive income, you should consider making your employees sign a separate confidentiality deed. Think the KFC, secret kernel recipe. That's what I always think of when I think of that trade secret. It's important to have a clause clearly stating that any IP developed by your employees during their employment belongs to you. This is because, by default, intellectual property belongs to the original author. The starting point is to identify the information that can be protected. Now, when you try to enforce restraint clauses, you have to prove that there is a legitimate interest that needs protection. Often it's confidential information, usually trade secrets, that gives the business a competitive advantage. Identifying that information, ensuring that your employment contracts and confidentiality deeds protect that information is key to preventing or stopping that competitive behaviour. Finally, it's important that the person drafting your employment agreements understands the difference between the information that is capable of being protected and what's not, having regard to your business. Another way to ensure that your sensitive information is protected is to implement information barriers and limiting access. Most restraint disputes involve employees downloading and extracting confidential information to their personal device or sending it to their personal email address. This usually happens before the employee leaves, and by the time the employer finds out, it's too late. We recommend that you conduct regular IT surveillance and random email audits to ensure that employees are not misusing that confidential information. If you don't already have a workplace surveillance and an IT monitoring policy in place, you should work with your lawyer to develop and implement that policy. This is because there are legal requirements that you need to meet before you start monitoring those employees. Work with an IT provider to ensure that your system keeps a detailed log of your employees' IT activity, and that log is kept for an extended period of time. This is so that during your random audits, you can quickly pick up any unauthorised activity. Also, in the event you discover that a former employee has engaged in competitive behaviour and find that they have taken customers and confidential information, and you want to take legal action, you have that sufficient evidence to support a case. Now, information barriers. You should also set limits on what employees can access. Consider having multiple access levels and privileges and setting up information barriers between different teams or sections of the business. Employers should not be allowed to have unrestricted access to information. For some information, such as templates or precedents, you could allow employees to view the information, but not download it. So this allows employers to use those templates to do their job, but they can't download them to their devices to set up a competing business in the future. Now ask the question, do they really need the information to do their job? If the answer is no, then don't give them access. Some business owners say, our culture is all about transparency, but that could come back to bite you down the track when you find out that your former client manager that you spent years training decides to leave and set up a competing business and hit the ground running in less than 2 weeks. During those 2 weeks, you've lost 5 of your valuable connections. You then realise that that employee has taken all of your materials that you spent years developing, and that's how they managed to service those clients immediately. The employee said to those clients, I can provide the same service for half the price. So work with your IT provider, or if you had an in-house tech team, work with them. Set up information barriers and multiple access levels and privileges. Now, when an employee resigns, some employers insist on those employees working out their notice period to make sure there's a smooth handover period. But that's during that notice period that they can start engaging in competitive behaviour, e.g. stealing information and start poaching customers. Instead, we recommend you place high-risk employees on garden leave. Now, what's garden leave? It sounds lovely, really, in theory. Garden leave suspends an employee from duty while they remain employed on full salary. They are required to stay away from work, but they can't work for anyone else for the specified period. Small business owners typically ask high-risk employees to work out their notice period. This is common with those businesses that rely on one person to do most of the work. Savvy employees, however, ensure that they work in a team to minimise the key person risk, so that the business is not severely disrupted by just the one employee leaving. So before you start placing employees on garden leave, think about how you can change the way you work. Ensure that work is evenly distributed and information and knowledge is shared across the business. We have a few tips on what you should do during garden leave. You should immediately collect all of the employees' work devices and suspend their IT access. You can conduct IT audit to ensure that the employee has not misused confidential information. This is so that if you find that if they've misused that confidential information, you can act quickly. You should be contacting key clients that are close to the employee and focus on winning them over and prevent them from leaving the business. And lastly, focus on retaining high-performing staff. You should spend time talking to the high-performing staff to prevent them from being poached. The common scenarios where you might need to take steps to enforce employment obligations are as follows. Your former employee is disclosing, for their own benefit or benefit of a new employer, your confidential information or your IP. Or your former employee has commenced work for a competitor or starting a new business in direct competition of your own. Or your former employee is poaching clients, customers, or other employees. What do you do when you face one of these scenarios? Now, I've set out a step-by-step guide to enforce employee obligations. Firstly, always check the validity of your clause. The employer needs to prove the clause was part of the signed employment agreement and the former employee is now engaging in restricted activity, e.g. working for the competitor, and the business is suffering or could suffer harm as a result. The starting point is assessing whether the restraint is reasonable and enforceable under New Zealand law. Now, the courts look at the employer's legitimate proprietary interests, e.g. the trade secret or client relationship, the reasonableness of the restraint in terms of the time duration, e.g. the 3 to 12 months, geographical area, and the scope of restricted activities, including the employee's role and seniority. Second, it's important to gather evidence of the breach. You must show that they're in breach of the clause. Therefore, you need to gather the employment contract with the restraint clause, any evidence of the new employment or business, e.g. LinkedIn updates or business listings, and any communications showing solicitation of clients or staff, if applicable. Third, we recommend, before going to court, sending a formal legal letter to the former employee. Identify the specific restraint provision. Explain how they are in breach of it. Demand they cease the offending activity and warn of any potential legal action. The cease and desist letter will require the employee to provide a substantive response to those allegations, hand over all the confidential information, and sign an undertaking confirming that copies of the confidential information have been destroyed, that they would comply with their obligations under the Employment Relations Act, and to cease all competitive behaviour. A further step would be to send a letter and an undertaking to the new employer. The letter would alert them to the employer's obligations under the employment contract and request them to provide an undertaking that they would not induce the employee to breach their obligations under their former contract. The next step, if the employee fails to comply with that cease and desist letter or simply ignores it, the employer will need to decide whether or not to commence the court action. This would involve applying to the Employment Relations Authority for a compliance order or seeking an injunction from the High Court, particularly if urgent relief is needed. Now, it's important to act quickly because one of the key elements that the court looks at when deciding whether or not to grant an injunction is whether you would suffer irreparable harm that cannot be compensated by money. The longer you leave it, it will be difficult to convince the court that injunction is necessary because more than likely the harm has already been done. Now to the costs. Restraint cases are not cheap, and this depends on how complex your IP or your confidential information is. It's important to engage lawyers that understand your business, and that's because if they already understand your business, you can save a lot of money as they will need to prove the judge that your business is under threat and it requires urgent protection by the court. Now, there are, of course, alternative dispute resolution options available, such as negotiation, arbitration, or mediation. These alternatives serve to minimise the cost and time expenditure associated with unnecessary litigation. It also may be in the party's best interest to settle the matter out of court, particularly having regard to matters such as commercial viability and reputation. The benefits of engaging in alternative dispute resolution is that you may be able to reach a compromise or some form of agreement that's quicker and helps minimize the impact on your business. Even though it's important to try to move quickly to get an injunction, this will only be an interim injunction, and you could still be up for a year or more of a fight in the courts, let alone the costs. The main purpose of the interim injunction is to safeguard the subject matter of a dispute pending the final determination of the matter. Now, when considering litigation, you need to be confident that post-employment obligations are reasonable and likely to be enforced. I have talked today about what is generally considered reasonable and unreasonable. Courts are primarily concerned with the question of whether, on the balance of public policy and protection of the interests of the parties concerned, it warrants the relevant obligation being upheld. A court will seldom enforce an obligation that imposes limitations disproportionate to the business interests sought to be protected. The restraint must be not too broad, and the interest must also be legitimate and be able to be identified. If the proceedings are to be commenced, do you have clean hands? The circumstances of your former employer leaving your business may be relevant. For example, any contractual protections you have may be invalidated if the employer first breached the employee's contract. Even if there has been no wrongful conduct, the courts may be reluctant to enforce obligations where the employee is not the author of his own misfortune. For example, the employee was involuntarily made redundant, or other circumstances surrounding the termination of employment may be relevant. Now, when it comes to remedies, there are a range of remedies that might be sought, including a final injunction, and this would be to prevent the former employee from engaging in any activity that violates the contractual post-employment obligations. This injunction could be enforced for a specified period. Damages, to address the harm caused by the breach. Employers may seek damages as compensation. Now, the onus lies on the employer to substantiate and present evidence of the losses, and that's where that evidence becomes important. That they can show that they have endured as a direct consequence of the employee's breach. Account of profits is in cases where the former employee has benefited from their breach, employers can demand an account of profits. This measure ensures that their former employee does not gain an unfair advantage as a result of their wrongful actions. And lastly, a declaration from the court that the restraint is valid and enforceable, and that the employee is in breach. And this basically helps clarify the legal rights, even if other remedies like injunctions are not pursued immediately. So in summary, start by getting your employee contracts reviewed and updated, preferably by legal advisors, to ensure that your business is protected. Your legal advisor should review whether the post-employment obligations, such as confidentiality deeds or non-compete and non-solicitation clauses, are enforceable. These contractual provisions help safeguard sensitive information, IP, and client relationships. Consider tailoring the contract to the employee. A one-size-fits-all approach is not necessarily a good strategy. It is important to consider the unique risks associated with each position in your organisation. Ensure your employees are aware of their obligations. Consider regular training and highlight the importance of protecting the business's confidential information and intellectual property. Always implement good employment and HR practices. Disgruntled employees are more likely to disregard their obligations to the company. Ensure that they are identified early and address the issue. Implement strategies to ensure your confidential information and trade secrets are protected. That means limiting access and maintain access logs. Conduct regular security reviews. Be vigilant in protecting your business's confidential information and intellectual property. Manage those outgoing employees by conducting exit interviews and developing strategies to improve culture. Exit interviews also identify high-risk employees so you can act quickly before the damage is done to your business. Take swift action. If you think a former employer is in breach of their obligations, don't sit on your hands, get legal advice and move quickly. Now, that concludes the main part of our webinar. You might find our publication useful, referred to on this slide, about how to hire and inspire. And this is located in the Resources tab or by scanning the QR code. We do have an upcoming event which you might be interested in, Marketing Mastery, Promoting Your Business Safely and Effectively. And this is on the 10th of June at 12 p.m. NZ time. We're going to answer your questions shortly. And while you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trade mark registration and much more. As a LegalVision member, you don't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all your business as usual legal work so you can focus on running your own business. And if you are an in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about membership or desk extension, request a free consultation when the survey appears at the end of the webinar. And now to some of your questions. So this one, what happens if I don't discover a breach until months after the employee leaves? Now the answer is you can obviously still take action. It's preferable if the restraint period hasn't expired, and you can demonstrate the ongoing harm or the breach of that clause. But obviously, as I said before, any delays may weaken your case, especially for injunctions. And obviously, yeah, the sooner you jump on it and notice what's, there could be an account for profits. But yeah, likely you would find out potentially afterwards and then you're covering up the mess, but it doesn't mean you can't take action. What's the difference between a non-solicitation and a non-dealing clause? So the non-solicitation prevents them from initiating contact with the clients or staff, and the non-dealing prevents them from doing business with the clients, even if the client initiates the contact, which, yeah, the non-dealing clauses obviously offer stronger protection, but slightly harder to enforce due to the fairness concerns. Should I use a restraint of trade for all employees? Our blanket answer is no. It just means that they're slightly less enforceable. And as we said before, like it is preferable if you prescribe it to the seniority of the employee, their access to certain clients. And as I said before, if it's, like an administration staff and you're putting 6 months on a restraint of trade on them, then that is likely to be considered unenforceable. very dissimilar to a, senior exec who's been paid 250K, and, that I would be putting a 6 months restraint, and then potentially even longer on non-solicitation. Can I sue a new employer for poaching my staff or encouraging breach of contract? So, yeah, if you can prove that the new employer knowingly induced the breach of a valid restraint or confidentiality clause, or acted unlawfully in soliciting staff, especially if they took multiple people. The proof is hard, obviously, and courts can get cautious. So in a lot of these situations, it is really helpful to have some sort of evidence trail. And, if they're advertising on LinkedIn or any other type of social media network, that's quite easily to just get snippets. Not many people use, papers these days. So it's not like you can cut out a clipping from a newspaper. But yeah, the more evidence you have, the better. How do you navigate the issue of preventing non-compete with the employee's right to work in the industry without restricting employability and the right to earn a living? So yeah, I mean, all of these situations, if presented in front of court, are generally quite unique as to the person, the industry, what they're trying to protect, because they've got to have that legitimate proprietary interest, and what would be considered reasonable. There's always the examples of the hairdresser or the barista. They seem to be the ones who float around in the case law that everyone knows about, and whether, if you're working in a cafe or a hairdresser and you go to work 2 doors down, and you take your most valuable hairdressing or coffee clients. There is situations where that has been enforced, but it is unique to whatever they're trying to protect. And if they're legitimately going out and saying, don't go back to that coffee shop, or bad mouthing you, or you have evidence of that's obviously more helpful than someone who just goes down the road, starts making coffee, and naturally you prefer that person's coffee making skills. So that there is a balance there. And generally it does come down to a case by case basis, on that, and, the geographical area. And it does get tricky when you get into people who work remotely, and obviously, some people say all of New Zealand for a geographical area. But yeah, in the instances of stopping someone, who's a plumber, to stop going for another plumber, it is quite tricky, and obviously the courts have to balance that up. Yeah. Can I stop an employee from using knowledge or skills they learned on the job? The answer is no. You obviously can't stop someone using general industry or knowledge or skills that they have acquired. You can only stop them using, trade secrets or the secret kernel recipe, confidential information, and client relationships developed through their role. Can I require employees to tell me where they're going after resignation? You can ask, but obviously they're not legally required to disclose their future employer unless it's contractually required, e.g. a conflict of interest clause. But no, the answer is no. Some employees might tell you, in the interests of softening the fact that they might be going to breach their contract. So I think that's it. That's all we have time for today. Sorry if we haven't answered your questions. Please submit them in the survey at the end for assistance with questions we didn't answer, or to learn more about how our membership can help you. While this is a free webinar, We value feedback, so please complete the 30-second feedback survey at the end. Thanks for joining us.